Students, this is the third video from the topic of discharge of contract. Here is once again reminder about the concept of discharge of contract. A contract is said to be discharged when it ceases to operate, that is, when the rights and obligations created by it come to an end. So, in simple words, you can say when nothing is left to perform for each parties, the contract is said to be discharged. Today I will explain third mode, which is discharge by subsequent impossibility, regarding section 56. To explain this point, let me share with you the concept of initial impossibility and subsequent impossibility. What initial impossibility means? An agreement to do impossible act is void ab initio, means right from the beginning. So any agreement which is made regarding impossible act is considered as void agreement, and technical term we use void ab initio. It means agreement which is obviously impossible, cannot be binding on the parties. For example, an agreement to discover treasure by magic is void agreement. So here you can note this agreement is initially impossible. So where their agreement is initially impossible to perform, for the parties to perform, that agreement is void ab initio. So this is a case of initial impossibility. The next is subsequent impossibility. Here subsequent impossibility means the impossibility, or you can say the act which is difficult for the parties to perform after the formation of a contract. Sometimes a contract capable to be performed after formation becomes impossible or unlawful, and as a result void. It means that subsequent impossibility or illegality will make the contract void and the contract will be discharged. We have few factors to discuss which are, you can say, cause impossibility of performance. The first one is on your screen, that is destruction of subject matter. When the subject matter of a contract after the formation of a contract is destroyed without the fault of the promisor or promisee, the contract is discharged. Here is example for you. G contracted to sell onions to K but failed to supply as the crop was destroyed by the pests. The contract was held to be discharged. The reason, destruction of subject matter. Students, here subject matter is buying and selling of onions. So when onions are destroyed by the pest, the parties are free from their obligations and they are not held responsible if it is nobody's fault. So this is the reason where their parties are discharged from their obligations. The next is failure of purpose, where the formation of contract depends upon happening of a certain event, and if that event does not happen, the contract is discharged. You can note here the base of this agreement, or you can say the agreement of such types, is on particular purpose. So when failure of purpose takes place, the parties automatically release from their obligations. Here is example: A hired a room from B to see the coronation of king. Due to king's illness, the coronation was cancelled. B sued for rent. It was held that A need not to pay the rent as the contract was discharged. Here the purpose of hiring of room was to attend the coronation of king. So the ceremony of coronation cancelled due to the king's illness. It is a case of failure of purpose. So when failure of purpose takes place, the parties release from their obligations automatically. The next case is death or personal incapacity. That is a genuine reason to release the parties from their obligations. Students, where the performance of a contract depends upon personal skills or qualification or the existence of a particular person, The contract is discharged on the illness, incapacity, or death of that person. So you can say death, personal incapacity, or illness release the parties from their obligations. Example, A and B contract to marry each other. Before the time fixed for marriage, A dies. The death of A definitely release the parties from their obligations. So the contract becomes void. Here comes the next, that is a change of law. Sometimes contracts which are lawful when made become unlawful due to change in law. Subsequently, such contracts become impossible to be performed for the parties. To support this statement, here is example. A promises to sell B wheat, but before delivery, the government banned the sale of wheat by private traders. The contract was discharged. The next one is declaration of war. This is the last supporting element regarding the discharge by subsequent impossibility. A contract entered into with the alien enemy during war is void ab initio. A contract entered into before the commencement of war remains suspended during the war. However, such contract may be revived after the war is over if the nature of contract so permits. Here is example for students. A contract to carry cargo for B at a foreign port. A's government afterwards declares war against the country in which the port is situated. The contract becomes void. So the declaration of war will make the subsequent impossibility for the parties to perform their parts. So this is all about the third mode of discharge of contract, which I have explained. For more videos, stay tuned. Goodbye.